not confuse the steps in this. The first
No,
is
it's not the step. The question is who, Dennis, can identify.
well,
right?
anyone can raise the issue
Right.
to management. They don't raise the issue to the tenant. Well, actually, you know what? If it's something plain and simple, we should speak to each other. We are neighbors. We should not be counting on the board or the management to be the Gestapo of this. If it's something simple, you should approach your neighbor. I've made mistakes. I left garbage out in the hallway one night, and I felt so bad I went around to apologize to the people around me for leaving it in the hallway. I forgot it was out there. There's so much of this that could be resolved at a very early stage, simple ones. Now, bigger ones, screens fall down, alterations without permits, all of that should be brought to the attention of Yvonne so that she can then send the notice of potential violation, which must be in writing, can be certified mail, email, U.S. mail, or hand delivered. Those are the four methodologies that you can give someone notice of the possibility of a violation. They have a cure period. After the cure period, if it has not been cured, then the board will send a certified notice of the actual fine. That's when then after that is when you have the 14 days before the hearing. The hearing occurs after 14 days. That's where the committee, their main role is to sit right there and decide whether what has been presented to them is a clear violation of a policy, and if so, yes or no, the fine that has been notified by the board. It's not like a relitigation. I hope that helped.
Holly online has a question. Holly, you raised your hand?
Right. So I was just thinking about, the tiers of penalties. So like, are we going to be sending out certified mail for someone who hasn't picked up their dog poop? And now we are looking at costs of sending out certified mail.
Let me ensure whether it just has to be in writing or it has to be certified. I will follow up on that.
I understand for like the bigger penalties of like the screening, because that definitely caters to, the aesthetics of the building.
I'm looking to see what methodology it has to be. It just has to say notice authority. It has to be in writing.
So when I asked that question, Dennis, you said that the recommendation on the certification is when the fines are imposed, not the initial notification,
Correct.
like for repetitive things. So I think I hear your concern, Holly. We incur all these expenses to send out emails and notifications, but I would expect that and those that we are sending violations for in a certified format are those that we're headed down the path towards legal action, and it is well within I guess the right to send it certified, right? I mean, you definitely want to make sure you have something on record if you're going down the path of fines and repeat offenders, right? You want to spend that money to get it on notice.
Yep, thank you.
And
It does not have to be certified. It just has to be in writing, and it can be hand delivered. And email counts.
Okay.
Sounds good.
Yeah.
I'm sorry, something to say. So having to put this into consideration with owners or renters being penalized for screen damage to get the screen repairs, what about on the whole of the association? What about persons? Because the association is responsible for doors. For anybody's doors in the unit, it is in the contract, in the original rules and regulation of the condo.
Yeah.
For many, many years. Yes, ma'am.
Dennis, you want to take over here?
So
Okay, we have discussed, we have debated, we have gone and gotten a legal opinion.
for entry, the condo.
And it doesn't matter if it was wrong for the last 40 years.
Yes.
I'm sorry to
No,
tell
I'm
you,
not
you weren't
incorrect.
impressed.
I'm going to get the book of the bylaws and show it to you guys.
I have welcomed all of you to
Dennis.
comment multiple times on this conversation.
I have it in writing in front of me. Yvonne, I don't know who is speaking in the room, but would you please make sure that they get a copy of the November 3rd, 2025 communications with Andrew Black that specifies the condominium association bylaws, the section and the definition of dwellings, the Florida statute, limited common elements, and and it talks about the details of common elements, limited common elements, and that the doors, windows, sliders are the owner's responsibility.
Please don't think that I'm happy. Do not think that I'm happy about this answer. I'm not happy about the answer, but it is nonetheless the answer. In order to do what people are asking us to do, let me tell you what that would require. It would require every single deed to be re-recorded and the doors be included in the limited common elements that are listed in the statute. I assure you that that is the answer. The limited common elements are in this property, based upon the statute, are the parking spaces that are pertinent to our unit, and that is it. You can read it in the bylaws and the deeds and every bit of it, every piece of it. We have been through this a lot.
And this document that I'm asking Yvonne to provide clearly articulates the logic behind this, right? And if you think about it, the folks that are end units, right, and they have windows, they have to submit an architecture approval to replace those windows and doors. So you think about those units, why would it be any different for your front door?
And if
You
you're
know,
efficient, that as well.
Yeah, Yvonne, and I don't know, it might be worthwhile to get these posted, that memo posted on Buildium, so that everybody has the benefit of reading through the legal opinion and the document.
Helen, you have a
I
question?
just have a comment that our committee took the rules and regulations, we've never met. We received the information from Dennis, but we've never had, the three of us have never met. So again, that's another thing that we need to go ahead and have a meeting, because if I'm going to be sitting with two other people in front of somebody who comes up and has got a screen problem,
Absolutely.
or problem, you know.
Yeah, Helen, that was the original question that I asked Dennis, and Dennis went down the order of execution, right? The first step is to get this resolution signed, right? Dennis, did you want to go over the next steps for executing?
Yeah, I wasn't quite sure I heard all the question.
She was saying, when does the standards committee get together and start executing against enforcement and the hearing? What's the order of execution?
Well, the committee would not be called into here from the tenant until 14 days after the issue of an actual violation and fine. So during the time that they're talking about it, or during the time that we've given notice of the time to cure, there's no reason for the committee to be involved during that time frame. If it's determined that it's cured during the time period, then the fine's never issued. If the fine is issued, then 14 days there has to be within 14 days there has to be a hearing, and that's whenever the owner or the tenant or who has to respond to it has the opportunity to say what they're part of it, and the board. That's whenever the committee just says yes or no to what the fine, what the violation was, was there evidence of it. It's not like a trial. It's not like there's not a prosecutor. I'm not going to come in there and prosecute the case on behalf of the. This is things that should be reasonable on paper that you can understand it based upon because it requires pictures and proof whenever you issue the fine.
Yeah, Helen was asking when we start to get together so we can start the process of this. So we will reach out to you, the three of you, to get together and you can discuss together amongst yourselves. Yeah.
I have to create, we have to make sure that we create the forms and the process for them. That's not their obligation to do that part of it. Their obligation is just to rule on it whenever it gets to them.
And I have another question here, and then Tony.
I want to make sure that Helen's question was answered. Helen, do you understand what Dennis is talking about as far as the process, right? The first thing was to put this resolution in place that but specifies the fines and the process, right? So once the notice goes into the management team and they send the notification out and the fine, the violations, right? Then the standards committee comes into play if the person who is getting the fine or the notice is not happy with it and wants to, question whether or not they violated. That's when the standards committee comes into play. Okay?
Like
Okay.
every, in my kitchen door, they have spots and things on it. And for 27 years that I've lived here, the condo association has always taken care of that because they have to match the paint, they have to do the work.
I understand, but it wasn't their responsibility. It may have been done, but it wasn't their responsibility to do it at the time. The spots actually come off with soap and water. They come completely off. You can clean your door right away.
I can scrub the door.
You don't even have to scrub. You could just wipe it with some Windex. That comes right off. But as far as paint, we have the paint in the office, and we are able to give you a gallon of paint, and it's free. There's no charge for it, and you can match the paint up. That's what everyone's been doing. That's what I've been doing with them.
That's not how it was in the past.
I understand, but if other members of the old boards were doing that for you, it was a bonus because it's technically not part of the condo responsibility. Okay?
And the torn screens that are caused by the trees on the property?
If you show me that a branch went through your screen, that's a whole nother ballgame, and we can discuss that.
Also damaged my car. I've had to take care of that myself. I didn't want an extra tree there.
You have to show, I need some proof, you need to bring me photos, and you need to show me. I'd be happy with that.
We have had situations where the palms on the trees have ripped screens, and we have had maintenance go in and repair those screens. So it does happen. And if that does happen, we will come in and fix that situation. But like Yvonne said, just bring it to her attention, let her know what happened, and it will be addressed.
Tony, you have raised your hand?
Hi. I have
Hi.
a question. In regard to the fines, how is the association able to fine people when it's not in the condo docs, and the condo docs have not been amended for the Kaufman language?
Tony, I already addressed that it doesn't, the fining is provided in the statute.
Correct.
So it does not have to be in the condominium documents.
Correct. But
But
what
even-
about
but
the
even if
Kaufman language?
Well, the Kaufman language discussion is still going on, as you well know.
No, I don't know that. No, I don't know
Well, the
that.
Supreme Court has not finished the whole Kaufman conversation, but that would
Okay.
not change this. This is not like talking about assessments for maintenance.
Okay.
And the things that are covered under Kaufman. This is fines that do not result in forfeiture. So it's a completely separate category.
Dennis, for the benefit of the others, can you please explain Kaufman? Just briefly.
I'll try to just briefly. It's not a short conversation, but and if some associations have objected to the requirement that the structural reserves be fully funded, saying that it is a change in the contract that they entered into whenever you purchased the condominium. The bylaws and all the things that we have that run appurtenant to it, they're covenants that run with the deeds that you agree to. The Florida state constitution has a provision talking about changes in a contract, and some associations have argued that they cannot require 100% payment of reserves because it is a change in the contract, and if Kaufman language does not allow for it to be changed, if there's not language allowed it to be modified, then it can't be changed because it changes, it violates the contract clause of the Florida Constitution. That's as plain as I can get it. This is not changing your ownership rights. The fines and committees does not change the ownership rights. It's not a change of any property interest, so it would not fall under Kaufman. Kaufman is an issue because failure to pay assessments can result in forfeiture, and that's where the difference is between this and that, between fines and assessments. But the Kaufman language has been argued that if your deed does not say "and as amended" after the first sentence, then it cannot be amended. Tony is correct. Ours does not say "as amended."
Okay, so my question is, Did you get a response from Andrew Black, the association's attorney, if you can do fines? Do you have a legal opinion?
We do not have to go seek a legal opinion for every single issue that comes up.
I didn't ask
That's
that. You do not have a legal opinion.
The answer is no, we do not. We
Okay.
do follow the statute.
Maureen, can I get that legal opinion? I asked for it in regard to the doors, please. Am I able to obtain that?
We can certainly put it in front of the board. You know, every time we reach out to legal, it requires us to pay like.
No, he's asking for the one for the doors that we already have done.
Oh, the doors? Oh, I'm sorry. I thought you said fines.
No.
Yeah, we already have one for the doors.
Okay.
Yeah, Yvonne, could you be sure that he gets that email dated November 4th?
Yes.
Thank
Good.
you.
The other thing is, does the fine committee, are they covered under directors and officers insurance?
Well, that's another whole ball of wax of different, but they are not, because they are not making any, they are merely approving or disapproving of something that someone else decided. They are not making the decisions. They're not the same as the board.
Oh,
But the answer to your question is no, they're not covered under that insurance policy.
okay. And the other thing I have a question for is,
If you want to consult with that committee to let them know what their risk is for saying yes or no, the violation
I'll be happy to
stands.
cover it in an individual meeting.
Yeah,
okay, and
Anyway.
the other question I have is, as I recall, any change in rules or amending new rules or something such as fines, it requires a 14-day notice. This is only a 3-day notice. Does that have any effect on the viability of your collecting fines, or it just doesn't matter?
we're passing the resolution. I'm just saying, I want to make sure I'm understanding your question. Are you saying that we need a 14-day notice to pass a resolution
Well-
that specifies fines? Is that what you're saying, Tony? And if so,
I'm
could you
saying
cite-
any change
cite
in the
where that-
rules, as I
Can I
recall.
finish, please, Tony? Can I finish,
sorry,
please? I'm trying
sorry.
to clarify your question.
Sorry.
So the question is, you're asking us whether or not it is appropriate for the board to pass this resolution in front of us for consideration without giving a 14-day notice, because some law dictates that we give 14 days notice that we're going to start imposing fines. Is that correct?
Correct.
And if so, could you please cite where that is coming from?
Well, as I recall, no, I don't remember off the top of my head, but as I recall, any change in the rules or adding rules or doing any change in the condo situation for residents requires a 14-day notice.
I would like to point out and repeat what Dennis said.
Okay.
This is formalizing what the Florida statute already allows.
Okay.
I appreciate your concern,
Right.
but unless we have facts in front of us
Okay.
that indicate we cannot pass or vote on this resolution, I would recommend we proceed.
I think you should do anything you want to do, Maureen.
Awesome. Any other questions? Just call me Donald. I'm sure that'll make you happy.
No. You would have to have a brain in your head for me to call you that.
Okay, touche.
Touche.
Just so everyone knows, we are not amending, we are not changing, we're not doing anything to the bylaws or the covenants or the deeds. We are merely creating a functionality to do what is already authorized.
Just remember, Dennis, you did not get a legal opinion from legal counsel. This is something you all decided to do on your own.
We did.
Wonderful.
And we got the idea from all of our residents because they want to be clean and safe.
Excellent point, Yvonne. You know, there's a law that requires or allows for the dogs around the pool, but you choose not to allow that, so,
Let's stay focused, please, on the agenda.
yeah.
Is there any other questions, comments, or concerns about the resolution being put forward?
Frank is making a motion to approve the resolution for the rules.
I second that motion. All the ayes?
Ayes.
Unanimous.
Okay, the resolution passed. follow-up actions on the resolution.